Thanks for that introduction, Josh. My name is Christian Vanderpump. Josh has given you my introduction. This is going to be a presentation that doesn't involve what you typically see in fire engineering, but a lot of law and microeconomics behind the scenes. Probably going to be a little bit overwhelming, but the purpose of that is to introduce you to the vast amount of information that's really behind fire engineering and that hasn't been considered. So first, we'll start looking at some examples of industry problems, what microeconomics, market failures, and regulatory failures are, constitutional administrative law and its relevance, building law and tort law, regulations, building codes, deeming instruments and standards, legal drafting, errors in law, guidelines and the law, insurance markets, fire engineering, and why you're getting premium increases in your market, and better ways of teaching fire engineering. I don't currently agree with the way it's taught on some key issues, and some liability mitigation for fire engineers. It's really focused on the private sector more than anything. Okay, you've got a lot of industry problems in your market. It's not performing well. That is obvious. These things are really quite the issues you're dealing with are really not new to an economist, to be frank with you. Some of the evidence, the clear-cut case of evidence is inquiries, new laws and reviews in the UK, changes in laws across Australia, voluntary review programs, 4 years of fire reviews in New Zealand since the C clauses of the building code were changed. Can you see the whole slide, Josh, there?
Yes, we can see up to 4+ years of fire reviews in New Zealand.
Okay, the word introduce is not cut out?
No, it's all good.
Okay, good. Okay. Here's something that isn't looked at in any detail. That is when you over-regulate. And for example, economists watch this kind of thing far more than engineers because that's really our job. And this is just one of many cases where in the UK they're looking at scrapping a project because the UK's regulations are at statutory level, I should say, bringing in an extra stair because of the Grenfell related to the Grenfell Tower outcome. This is not the sort of thing you want happening. Another one in New Zealand is we've got building consent delays. This is actually across the board, but fire engineering plays a major role in this in terms of all sorts of unnecessary problems. And it's really, this is our Minister for Building and Construction, and it's really quite ridiculous that we've had building acts and building statutes in place for so long, and we have delays just getting a building consent. In Australia, recently introduced NCC clause A2G2 Part 4. Fire engineers in Australia will know about that one. Here we have building certifiers, I believe, writing to Association of Australian Certifiers, effectively complaining about that regulation that the Australian Building Codes brought in at post the Shergold-Weir Building Confidence Report, which they've actually got a valid complaint here, but it takes quite a bit of time to explain why this regulation has serious problems. What I've looked at, along with the university, is look into the fire engineering market, but how to correct for market and regulatory failures in fire engineering. So you start with the law and economics. Okay, it requires an understanding of microeconomics. It's a discipline which analyzes market and regulatory failure. The key areas of microeconomics are public economics, which looks at how public sector decision making, risk and information economics. That's actually fire engineering. It's one of the probability-based markets. And economic analysis of the law, which looks at how the law affects economies and sometimes where you need the law to stop perverse outcomes in otherwise freely operating markets. You need to understand the law. So where laws are needed to correct for market failure, you can also have bad laws, and then you end up getting what's called regulatory failure. So to understand how that kind of approach as well, you need to understand tort law, constitutional and administrative law, and a discipline in law called statutory interpretation. I just dragged this off the internet, and it's actually pretty good. A lot of the stuff in microeconomics is not that good, but this actually captures basically the 4 main areas of microeconomics where we study market failures. And I'll go through all of these, particularly public goods, in a little bit. But these are the four main ones, what's called public goods, and I'll explain that in a minute. Externalities, which is where you have third-party effects, such as pollution. Spread of fire to third-party property, that's an externality. You have abuse of power, which is typically monopoly behavior. And then we have what's called asymmetric information, where people don't disclose the information that they should, and that results in decisions that would not be made if information was otherwise fully disclosed. Other types of market failures you have in fire engineering is moral hazard, where someone else bears the cost for another person's lack of effort. You need asymmetric information is a necessary ingredient. It causes all sorts of financial losses. Adverse selection, where a consumer can't observe the quality in the market. Asymmetric information is a necessary ingredient. It causes bad actors to succeed over good actors in a market because the consumer can't tell who's doing their job properly and who isn't. So the bad actors can underprice the good actors, and then you have adverse selection. It's a valid reason for occupational licensing. Have what's called the holdout problem, where one person can hold out and extort what's called economic rents, unjustified benefits until they get what they want. It causes projects to be delayed or even cancelled. If you look at one of the legal databases that lawyers use to find relevant case law, if you look at the microeconomic terms, you see a whole pile of microeconomic terms that the judges refer to and accept all the time. Microeconomic findings are accepted by the court. One of the terms that's floating around in fire engineering is socio-technical. I'm not going to get into this in any detail, but it's just not recognized by the courts. It's not in statutory law. I would recommend just, in all honesty, giving it a bit of a miss. But as you can see here, the courts recognize what we do, and it's used as I've won cases myself using arguments based on some of these microeconomic principles. Constitutional law and how now I'm going to discuss a little bit of constitutional administrative law. What constitutional law is basically the founding law which gives birth to all other laws. So you need constitutional law to lay the framework out of a country so that other laws can be put in place. You have things called, one of the key ones is separation of powers, because most governments such as New Zealand, Australia, and the UK have three arms of government. You have the legislature, the executive, and the judiciary. They all act as a counterbalance to unbridled power. You have other constitutional issues such as freedom of rights of individuals, such as freedom of information, access to the courts, judicial review, right to petition, right to freedom of association. Administrative law is the sibling of constitutional law and embraces the legality of public decision making. So you have, and this is often you see a lot of friction between the public and private sector, and if you want to resolve it, you need to understand administrative law. You can argue technicalities all day long, but it comes down to administrative law if you're dealing with a government department, and it falls into a number of categories, such as error of law, error of fact, ultra vires, improper purpose, relevant and irrelevant considerations, unfettered discretions, and the like. I recently gave a presentation on this to just that topic alone to Institute of Architects in New Zealand to show them how to resolve disputes when they're having a problem with their building consents. You can change the direction central government makes when you know how to apply constitutional law, because if constitutional errors are being made, you put it in the right legal forum, they have to start changing their decisions. I'm going to focus a little bit on Australia's system here, but it's similar to the UK. It's actually founded off the UK. And New Zealand's is Westminster system as well. It's founded on the separation of powers doctrine. You have three co-equal arms of government: legislature, executive, and judiciary. And it's basically there to maintain democracy and control excessive use of power by any one arm of government. We'll see examples of that. Australia, for example, had started as a nation with a codified federal constitution on the 1st of January 1901, but it doesn't cover building and construction. Also doesn't cover tort law, which is accident-based law or harm-based law. Therefore, each state and territory jurisdiction from now on has the freedom to regulate building work as each jurisdiction's legislature sees fit. So each state's parliament regulates its own building affairs. Okay, for example, in Queensland, you have 93 MPs. You have a unicameral system. You don't have an upper house. You pass statutes, you pass the Building Act, And then if things go wrong under the Building Act, things like the Civil Liability Act come into play. So you've got to file for a claim in tort under the Civil Liability Act. Other states have their own building acts and liability laws there. I've just listed them out, but I'm not going to go through all of them. And but where they come into play with each other is what's known as statutory relationship. You don't, for example, for Australian fire engineers, see liability-based clauses in the National Construction Code, because the Australian Building Codes Board doesn't have the authority to specify legal penalties. Legal penalties are a state matter. Then you have the Queensland executive entities, which have an administrative role. They administer parts of the Act. You have the Queensland Building and Construction Commission. They can add or override NCC clauses via the chief executive of the QBCC. You see that with the Queensland Development Code. Other states can do this as well because the National Construction Code is not supreme law. Just as a microeconomic comparison between New Zealand has the Building Act 2004 and requires local councils to issue building consents. So local councils have monopoly control over the supply of building consents in New Zealand. So Australia has a competitive market for the supply of building consents by and large. There's some ifs and buts there, of course. So for instance, Tasmania is not quite the case. There's override provisions in Western Australia's Building Act as well. But you can see there's a major difference in how the markets work between Australia and New Zealand. That creates all sorts of different economic outcomes, good and bad. The devil is in the detail. The question for an economist is, which is better, state supply or privatization? Really comes down to this question: monopoly power versus what you can have as moral hazard, as well as adverse selection, things like that. Privatization is far better, but it needs to be regulated the right way, is a short answer. The judicial arm of government, fire engineers don't often pay a lot of attention to this, but what most people don't know is they can rule regulations invalid. And this was a big part of my research. To give an example, back in 93, to give an idea of just how potent the courts are, this judge, Justice Thomas in Paradise Projects, ruled a bylaw, wiped out a bylaw of a local council. And he went on to say here, the bylaws which I have concluded to be ultra vires, beyond the powers, are typical examples of lazy drafting. And we're going to look at examples of where you may have these problems in fire engineering as well. So, and this is actually a problem where people who draft regulations are not trained in drafting regulations. And this is a very widespread issue. So he wiped it out and he told the council to go back and do it again. That was it. They had no bylaws to regulate the issue that they were trying to deal with. They have that power, for example, in the State Supreme Court of Queensland Act, where currently now, they had their previous one was actually applicable. Currently, it's the 1999 Uniform Civil Procedure Rules, and that actually comes under Rule 11A, where the issue of the proceeding is an issue of law, and the issue of fact is not really the issue of dispute. So in this case, they're just arguing whether the bylaw issued under the Act was consistent with the Act, and the judge ruled no. So there was no expert evidence and things like that really played a role. And that can happen in any type of regulation, with any type of regulation. In also other statutes that actually play a major role in the background is you have, for example, in Queensland and other states have statutes like this, the Statutory Instruments Act, where it basically says here, Section 21(1), a statutory instrument is to be interpreted as operating to the full extent of, but not exceed, the power conferred in law. So it can't be ultra vires. And also says there distributively. What that means is the regulation can't go breaching other statutes either. Then you have other statutes such as the Acts Interpretation Act 1954. Again, other states have their own statutory interpretation acts. And this tells you how you're supposed to interpret a statute of Parliament and all the regulations below it. So you see there in Section 2, it says this Act applies to all acts. That's for the state of Queensland, of course. But you see a lot of engineers relying on the NCC guidelines to interpret the NCC. That's not the correct way to do it. And there's actually case law on that issue that I'll bring up a bit later. Well, here's a question that people is worth asking. And should be thrown at economists and see what answer they come up with is, why don't you just dispose of building statutes, codes, standards, and the common law and just work to contract? In other words, laissez-faire economics. Well, any economist has done their homework on this issue would tell you absolutely not. And the reason why is there's two fundamental types of harm that can come along with building failures. Buildings can fail and they can hurt people. Buildings can cause damage, and that damage can result in damage on third-party property. The first type of harm, it really is covered under the tort of negligence. And the second type of harm, such as spread of fire or even structural collapse to third-party property, that's covered under the common law of tort of nuisance. In other words, you would have market failure if it was left to the free market. Okay, so economists are not this representation in the media that economists are just do whatever you want is just not correct. It's not a correct, accurate representation of what economics is about. But if you get the regulatory structure wrong, you then get regulatory failure. To give you an idea of how influential economics is to the profession to law, this basically the one of the things that we study is the torts that the courts have developed over the years: torts of negligence, strict liability. What else is another one? What's called second mover, and so on. Bilateral care. But basically, you have five things you've got to work to under this tort, and we have what's called duty of care, where you've got to make sure you actually have an obligation not to hurt somebody else. You've got to breach that duty to have a claim. Then you've got to have loss. Then you have got to be the cause of that loss has got to be prescribed to you. What's known in law as the but-for test, and then it's got to be proximate. It's got to be not outside the. It's not going to be unforeseeable. But we study these types of this area of law, and we come up with our own mathematical ways, ordinal what's known as comparative statics, to determine what type of liability rules apply under what circumstances. And over the decades, generally speaking, those findings have been accepted. This is a book written by William Lands and Richard Posner, which is published back in 87 rather. It's out of print now, but I bought it secondhand because it's a valuable book. And on the inside cover, it used to be owned by a judge in the United States. And that didn't surprise me at all that it was there. But these books are actually very helpful in understanding the principles behind what it is, how the law is supposed to allocate problems in the most efficient way, solve problems in the most efficient way. One of the reasons why you have the obligation to provide a duty of care is because there's not actually the market would not actually work properly otherwise. And it comes down to what's known as public goods. I could spend a whole seminar on this, but I just want to show it to you in case you want to start looking this up. Public goods are what's known as non-rival and non-excludable. So a rival good would be something that consumers may use at marginal cost. So each person uses it, and another person wants to use it. There is an extra cost in that person using it. Something that's non-rival, that's not the case. So there is no additional cost to another person consuming that good. So an example is radio signals. One person turns on their radio. That doesn't affect another person who's consuming the radio signal. Then we have what's called excludable. You can't get it unless you pay for it or it's secure or something like that. Okay. And then we have what's called non-excludable goods, things that people can't be excluded from receiving. Fire safety precautions in buildings where there's an obligation to protect the public are non-rival and non-excludable. And the reason for that is everybody in the building gets the same benefit and they can't be excluded from getting that benefit. The problem that you have with such markets is who pays for it. Well, the building owner pays for it, of course, up until meeting the legal threshold. But it explains why building owners say, how much do I have to pay for? Why do I have to keep paying? Because they don't actually get the benefit. Everybody else, basically, except them, gets the benefit. But it has to be a public good. Otherwise, it's not going to protect who it needs to protect, which is anybody who shouldn't be excluded from getting that benefit. But it shouldn't be, don't confuse public goods with publicly provided goods. We have our own definition and effect of these things in economics. But you see here in this table here, those what's in brackets there are actually parts of the New Zealand Building Code, and each one is a different type of good. So structural elements that protect people inside the building, they're a public good too. Fire precautions are public goods. Aesthetic features, everybody sees them. You can't exclude people from not seeing them, and everybody sees them to the same degree, so they're non-rival as well. But you see, building codes are necessary to deal with the problems that things like public goods create. Nuisance, going back into the common law, basically interrupting another party's property rights. Water overflow, smell, structural collapse, spread of fire. Spread of fire under the law historically has been under the common law before building codes and building acts come into place, known as ignis sus, which is not in Latin, his own fire. Strict liability. Fire on your property, if it spreads to someone else's, regardless of the care you take, you pay. So very, very simple. Doesn't matter whether it's rubbish on your property, the building itself, long grass, ignis sus. Very, very simple. And then over the centuries, you had a case called Rylands v. Fletcher back in 1868, which changed the ignis sus strict liability rule to bring in a whole pile of ifs and buts. Ignis sus or Rylands v. Fletcher doesn't apply in Australia. There was a case back in 1994, before the NCC came into play, in the Australian High Court, Australia's highest court, known as Burnie Port Authority, that basically put spread of fire into the tort of negligence. But this is not the case in New Zealand or the UK. But you can see the history of fire safety law, primarily from the common law, is what's actually given rise to how we see things today, but it's actually been put into statutory form. You see this here, for example, in economics, what we call a negative externality, nuisance, exactly the same thing. Third-party effects. There's three ways of dealing with it. Regulation, control quantities imposed. Fire is typically dealt with by regulation. There's pricing mechanisms, pay to pollute. That wouldn't work in fire. Then there's what's called Coase theorem, and that actually does work in fire engineering, but most people don't know how to do it. But you see the doctrine of nuisance or negative externalities being dealt with in the New Zealand Building Act in that first white box there, where it says there in actually section 42II of the New Zealand Building Act, the need to provide protection to limit the extent and effects of spread of fire. And then you see further discussions down below in a book called Todd on Torts, where they discuss Rylands v. Fletcher, and talking about things like if something escapes and does mischief onto somebody else's property. A lot of legal literature and economic literature on spread of fire. Negligence and nuisance at the common law, do whatever you want, just don't be the cause of a negligent act or nuisance. Very, very simple to administer. The courts didn't care what you did, so long as you didn't cause harm or damage. Statutory law over the decades has replaced the common law, but it actually captures a lot of the principles. Basically, building codes are all building acts, and their subsequent regulations below them are all about basically three things: safety, health, and amenable buildings. Often this is discussed in the purposive objective section of a statute, such as the Northern Territories Building Act 93, where in section 3D, it says to maintain, enhance, and improve the safety, health, and amenity of people using buildings. But if you cause harm or damage, well, then you're now in tort-based territory, and in Australia, statutory law deals with this matter under, for example, the Queensland Civil Liability Act 2003, and you see the criteria there: duty of care, causation, assumption of risk, things like that. Each state and territory, other than for Northern Territory, has a similar thing. Well, what is the NCC? Most people just jump into the NCC without really even thinking about it. It's actually a regulation enabled by statute. Because the Commonwealth, the federal government can't regulate building law in each state, it has to be enabled by statute. So Section 12 of the Queensland Building Act 1975 enables the BCA or the NCC. Here you see building codes being discussed in legal literature that lawyers rely on that most people don't get access to. And you see down in the second paragraph there, the bottom paragraph, building codes are treated as disallowable instruments in the same manner as building regulations themselves. What a disallowable instrument is that's a legislative term whereby a member of parliament, if they think the regulation is wrong, they can put it before the House of Representatives, and if people don't vote it in rather, it gets voted out. So it's similar to the courts interfering, not interfering, but removing that regulation. So they can, if a member of Parliament in Queensland decided the NCC was not fit for purpose, they could try and wipe it out if they wanted to. The intent of the NCC is basically two provisions. You have two parts, performance requirements and what's called deemed to satisfy, which includes standards. Most people don't know that deeming instruments of law, sometimes referred to in statutes as deemed to comply or treated as, are what's known as a statutory fiction in law. Because if you follow a deeming instrument, it is treated as complying with the law. You actually haven't demonstrated compliance with the substantive legal thresholds that are above that instrument that you're using. And you see discussions here where where the court can actually, court treats it as a fiction. And if you prove it's wrong, the court will say, well, okay, the deeming instrument doesn't apply in that circumstance. The deeming instrument is wrong. Here's further discussion on the matter. The deeming provision may be construed to establish only a rebuttable presumption that the statutory fiction is to be adopted. Basically, it can be rebuffed and be demonstrated as wrong. It's very important because people rely on the deemed to satisfy as the right answer in demonstrating what they think is appropriate. It's just not always the case. And I'll show you some examples shortly as to where there's been some horrific failures. This is actually discussed in law literature, such as Dennis Pearce, who's a Professor Emeritus of Constitutional Law, Australia's #1 academic, retired from the ANU. In his book, Delegated Legislation, now in its 5th edition, he talks about things like material by reference. Material by reference is what you know as a standard. And here they talk about the validity of delegated legislation and then goes on to talk about whether could a standard, because it comes into a deeming instrument, be found invalid by the courts? And the answer to that is yes. And he just discusses it here. A very valuable book, often referred to in the courts. So deeming is a statutory fiction that can be found incorrect by the courts and ruled ultra vires by a senior court, such as the state Supreme Court. It's not statutory law. It's not even really law. It's a decision under the law because it prescribes a procedure that is then treated as a statutory fiction. Here we see C1V4, the Fire Safety Verification Method, and published by the Australian Building Codes Board, where Section 5C says it is accepted that the NCC deemed to satisfy provisions reflect societal expectations in terms of fire safety, which addresses individual risk, societal risk, and the robustness in the design of adopting a defence in depth approach. That's not correct. A deeming instrument is a deeming instrument. It's a statutory fiction. Well, who actually writes the laws? Most people just follow it without actually asking who writes it and whether they actually get it right or not. Well, the courts write the common law, and they get this right almost all the time. They do have appellate courts, and even the Australia's High Court can change direction. That doesn't happen very often. In Australia, in Queensland, for example, statutes in what's called Order and Council regulations, that's high-tier regulations, they're drafted by the Parliamentary Council Office. They do a pretty good job of writing legislations. They don't always get it. There's a political element to it. Left-wing party in power will want left-wing ideology, right-wing ideology, but nevertheless, generally drafted well. They usually get what's called Order and Council regulations right. When it's wrong, an Order and Council regulation is one that ministers have agreed to. The order it gets sent to the Parliamentary Council Office, gets drafted, and then gets certified by the I think it's the Governor General of your state. but it can be ruled null and void for inconsistency, uncertainty, or ultra vires. And you see this discussed in Dennis Pierce's book. The courts have the power to rule regulations invalid. Here's one of the criteria: inconsistency. The regulation is just not consistent with its parent act, because the parent act is the supreme law. That's been what's determined as law by Parliament, which is democratically elected. The regulation's got to be consistent with the democratic will of the people. But if it's inconsistent, it gets wiped out, or the part of that regulation gets wiped out if it can be what's called severed from the rest of the regulation. It can be found uncertain, goes back to a case called Cruz v. Johnson. If you just can't make head or tail of it because it's just, in all intents, just nonsense or unclear, it's uncertain. And the courts can wipe it out, because you can't be expected as a citizen to follow something that you can't figure out what it means. That doesn't mean to say that if you can't figure it out, that it's wrong. There's actually a step called statutory interpretation that people are expected to understand, but that's a different matter. So, does our Parliamentary Council Office draft the NCC to be consistent with each state and territory's respective Building Act, liability statutes, and the like? Because the NCC is not drafted at each state. There are changes, there are modifications at each state level. I get that. Are Australian standards drafted by the Parliamentary Council Office? The answer is no to both. This issue of questions whether the NCC has been that well drafted, whether there's issues in it, was actually brought up in a case about 5 or 6, 7 years ago now, where the tribunal was asked to try and make head or tail of what the NCC meant. This is for a cladding fire via statutory interpretation, where the only thing the experts agreed on each side was the NCC wasn't that well drafted. The judge agreed to a degree, but it raises an interesting question. And it's not a surprise. And we'll look at some other actual real failures where drafting below that of what a Parliamentary Council Office would draft have got things very, very wrong. Now look at the history of the NCC in Australia. Deeming provisions preceded the performance requirements. That's because you had effectively a BCA before performance-based building codes were brought into effect. It actually should be the other way around, but due to how each states and territories have signed up to a national construction code to facilitate trades, what's known as lowering transaction costs, the DTS effectively came first. Why? Because of the way Australia is constitutionally structured. Separation of powers, Parliament is supreme. You could not start with the federal government drafting a federal statute of building, a federal building statute that covered all of Australia. So each state and territory did their own thing, and then they incorporated DTS. A proper constitutional drafting sequence for any type of any way to regulate a market is you draft the Act first, Order and Council regulations second, performance requirements third, deeming instruments fourth, and material by reference last. That is not what's happened in Australia. You have You've had the performance requirements came after the deeming instruments. You've had material by reference come in well before that. It's really, I won't say a mess, but it's a challenge. However, the reality is that constitutional law doctrines apply, and there must not be inconsistencies with each regulation must not be inconsistent with those above it, and certainly not inconsistent with the Act. You see this constitutional law being applied in statutory law in New Zealand. In Section 17, all building works got to comply with the building code. Section 25 of the Building Act in New Zealand, the content on acceptable solution or verification method, which is basically the same thing as the deemed to satisfy, and similar to that of the UK's approved document. It says there in Section 25(2)(c), an acceptable solution must not contain a provision that is inconsistent with this Act or the regulations. That's just putting what the courts put in as a rule. So the Ministry of Business, Innovation and Employment, who draft and issue the acceptable solutions, got to produce acceptable solutions that are consistent with the Act and regulations. Well, when you actually look into, say, the verification method, there is actually an exemption to the New Zealand Building Code, Section 3(4), and it says here, you've got to apply that except in these following situations. That's a waiver to the building code, and the building code is an order and council regulation. So they've actually got something in there that's not correct. They've got to really clean that up. There's a whole backstory to why that's like that, but it shouldn't be there in the first place. And a few years ago, it actually wasn't there. But there's a whole backstory to why that drafting sequence has occurred. It shouldn't be happening. Back in around the late 1990s to early 2000s, New Zealand had what's called a leaky building crisis. And it resulted in tens of billions of dollars of economic damage because untreated timber was allowed to be put inside wall cavities of behind external cladding. And back in 2004, this academic, Peter May, said it was all caused by laissez-faire economics, and it was a result of New Zealand introducing a performance-based building code. Didn't provide any evidence as to where the problem actually went wrong. Just had his opinion. Okay, that's fine. I don't agree. And I'll show you why. The courts, back in 2005, Court of Appeal correctly identified the issue. What actually happened here is in 1998, the Building Industry Authority, which is similar to that of the ABC, Australian Building Codes Board, issued an acceptable solution that allowed untreated timber inside wall cavities, and you be guaranteed a building consent. So they got their deeming instruments, their compliance documents, their prescriptive cookbooks wrong. Everybody followed it, and buildings rotted from the inside out as a result of it. Yes, a performance-based building code was introduced, but people weren't following it. This was for domestic housing, where you just follow the prescriptive cookbook, and it's assumed to be the most efficient way. Well, it certainly wasn't here. In the UK, you see indications of a similar problem. BR 135, which is published by the Building Research Establishment, set out criteria for external wall systems to be judged acceptable. But when under cross-examination, the private sector created a regulation standard rather contained no explanation of those criteria or any indication of what they deemed to represent, and their witnesses couldn't explain why they did what they did. Not only that, under cross-examination, they BR 135 does not relate back to the criteria of the building regulations or the guidance contained in approved document B. So very interesting to find inconsistencies in these industry published documents that ultimately contributed to, most likely, widespread combustible cladding problems. In New Zealand, in our prescriptive documents, 584 in the acceptable solutions, we have reference to BR 135 as an approved solution. We just adopt standards and industry-based documents and put them in written foreign countries and then put it in our own. Here's another example. Section 42I of the Building Act. It's very clear. You design buildings to limit the effects of spread of fire, particularly with regard to whether household units on the same land or on other property. The objective of Clause C of the Building Code, which deals with our spread of fire, that was covered in C3.1, which says here to protect household units, other residential units, and other property from the effects of fire. It captured that criteria. The C clauses were redrafted, and they were actually redrafted by people who were not developed by people who were not parliamentary council drafters, and they left out the bit about dealing with spread of fire between household units on the same land. It just says to protect other property from damage. That's being fixed at the moment. Back in 2011, New Zealand had a very bad earthquake, and that earthquake was in Christchurch. And before then, houses were built with foundations that didn't have reinforced concrete, and the concrete pads were structurally broken up. And the theory was when the earthquake comes along and the liquefaction hits, the plates will float around, and then after the earthquake, it'll all settle back and it'll be good. Well, all that concrete cracked. The foundations were cracked, so the houses had to be demolished. And then there was an emergency job on the New Zealand standard that was for domestic housing. And it then imposed that you had to build foundations with reinforcing steel, reinforcement in the foundations. So it doesn't just happen in fire. Here's a case a few years ago now, back in 2012, where they built the building and they interpret the building height based on the NCC guideline. Well, a big fight broke out and they went to court, what was known as a separate question, because it really came down to one question: did you interpret the law correctly? Because after that, the facts will lie on one side or the other. And the judge said, I formally rule the guide is not relevant to the determination of a proper construction of the definition of effective height in the BCA. It's not a statutory instrument. And he says at 110, it is that text, meaning the NCC, not anything in the guide, that was subject to the adoption and application by regulations made under the Environmental Planning and Assessment Act. The NCC guides are not statutory interpretation tools. They're not regulations in any capacity. The rest of it didn't go to court. They didn't need to. Everybody knew what was going to happen. This was a fire safety private sector get together, if you will, where with the Warren Centre, I believe, and this is one of the reports they produced, and they were looking at using the Australian Building Codes Board assessed a number of guidelines, all written in foreign countries, and then developed their own criteria as to whether they thought they were suitable or not. Well, it's got nothing to do with statutory law or common law criteria that is still relevant. Nothing to do with inconsistency, ultra vires, or uncertainty. So it may be okay in certain circumstances, but you've got to be very careful. And it really pays to go back to the principles first. A bit of microeconomics on risk and insurance. I haven't covered as much economics as I'd like. The frequency and severity of fires is going down in the aggregate across OECD countries. Okay, I've got the data for the last 30 years across Australia and New Zealand on that. It's crystal clear. So the cost of claims from fire damage is down from 1990 to the current. But insurance premiums for fire engineers is going up. Some insurers are actually walking out of the market. Why? What you're dealing with here in your market when your insurance premium is going up is a phenomenon that insurers know all too well. And just because they don't tell you doesn't mean they don't know what it is. And you're dealing with a market phenomenon known as moral hazard. I don't have time to get into it, but I think that I think that some of your technical societies might need to. I would recommend having a look at this issue. For example, Berkeley Insurance is not underwriting fire engineers, and in the UK, they're having trouble getting engineers, or it's very expensive. This happened in New Zealand about 20 plus years ago now, where with the leaky building crisis, all the private building certifiers either went out of business or couldn't get insurance. The entire market was wiped out. So this is economics. Understanding this problem is microeconomics at play here. Is not fire engineering, but it is relevant to what you do. There's a bit on teaching fire engineering. This is a course in Canterbury University, NFU 605. I've actually spoken to the department about this. I've made my position very, very clear about it. I don't agree with the structure and the way it's taught. They start with compliance documents, deeming instruments, acceptable solutions, verification methods, and then they go into the procedure for your IFEG based performance-based design. In my view, they should be starting with the Building Act and understanding the basics of the tort laws that underpin the Act, doctrines of negligence and nuisance, a little bit of statutory interpretation, and then working through the mechanics, the whole scheme of the Act, and understanding the difference between objectives, in the case of New Zealand, objectives, functional requirements, performance criteria. I actually talk about that in my next slide, I think. And you see here in this case law, where this is actually the Supreme Court speaking here, no one can be party to the construction of a building which doesn't comply with the building code. The duty in tort imposes no higher duty than that. Well, if you're not coming out, my position is if you're not coming out of university, you're not having an adequate understanding of where your duty in tort applies and what it really means, your education on this is not complete. So I think that a bit of a rethink on how fire engineering is actually done would actually go a long way to sorting out a lot of the industries. You start by explaining the Act and how statutory law works. It's not simple, but you need to do it. Who has what duties, function, and powers under the Act? You see a lot of disputes that just don't need to happen because people are often trying to do things they shouldn't do. Say a government department wants to be part of the design team. Government departments don't have a design role under any statute across Australia. Okay. Explain the common law. Basically, the underpinnings of what it's all about, torts of negligence and nuisance, how to interpret a building code along with underlying common law principles. In the NCC in Australia, they've actually got a lot of redundant NCC performance criteria. I think you could simplify a lot of it. The importance of obtaining verifiable information by official information law. Too much sitting at tables with people just saying, I want this, I want that, I think this is the right answer. It's not verifiable information, it's out. And one of the issues that fire engineers try to stay away from, and it's understandably, but how to use efficient dispute resolution methods which are basically of an administrative law nature, so that you can solve your disputes efficiently. And things like the nature of deeming instruments, such as acceptable solution verification methods, they have to be intravised in Act and common law, why they can't be relied upon for statutory interpretation processes, certainly not guidelines. Some very simple things to help you along here. You can't be found liable if you comply with the Building Act of your jurisdiction. You can't be found liable if the regulations you work to complies with the statutory law. It's intra-vires, not ultra-vires. The information you rely upon must meet the legal threshold of verifiable. Anything other than a statute or order and council regulations is not drafted by a parliamentary council office. So the person who drafts it, they won't have skills in constitutional, administrative law and tort law to be able to know whether they're getting things right. Industry practice is not always correct. Plenty of case law where the judges throw that out the window. Deemed to satisfy material by reference can be wrong. You've seen examples of that. Fire engineering is underpinned by the common law of negligence and nuisance. It's not that scary to pick up the books and read about it. Microeconomic findings and methods are recognised by the court. I haven't really gone into how to apply that here today, but it is very powerful. And as all economists say, to be charming like all other economists, conferences, meetings, and guidelines are not the solutions to the problems you have in your industry.
Hello.
Thank you to the SFP and Josh in particular.
Good, yourself?
Okay, Josh.
Excellent. Thank you for your really thorough presentation, Christian. Quite insightful for myself, definitely. There are a couple of questions in the chat. I don't know if you're able to see them and you want to just answer them yourself, or you need me to read them out.
Could you read them out? I don't see things too well on my screen.
Okay. So the first question was about half an hour ago. It says case law doesn't play a role in course correction, ?
Doesn't play a role in what, sorry?
Course correction?
Course correction. What does that mean? Course.
I'm not 100% sure. Jennifer was who asked the question. If you need to clarify, please do so.
Yeah, sorry. So if you have a foundation of that, this would be a tort type of situation. And my question is, in Canada and in the US, we have case law that can be used as a foundation for future tort cases. And it serves as a type of course correction to the original foundational law. I don't know how better to explain that. It is probably an administrative thing.
I'm not intimately familiar with the structure of how things work in the UK on those matters. In terms of, I haven't read things like the hierarchy of where things like whether judicial review plays a role in something like that. So I don't think I could really contribute to. I'd love to give you if you want to connect with me on LinkedIn, give me an example of what you found, and I'd love to have a look at it.
Yeah, I'll toss my LinkedIn into the chat.
I'll be happy to have a look at it.
Yep, thanks.
Excellent. We have a question from Jeff Lauer. In relation to public goods, where do non-required safety features sit? For example, if a property owner decides to install additional safety measures above the minimum requirements to meet safety requirements of the building code, the users of the property will benefit from those measures. What is the obligation of the owner to maintain or retain those measures? Example, they may install a specialist sprinkler system, I'm guessing, for some equipment, then later decide that the depreciated value of the equipment doesn't justify maintaining the suppression system and want to decommission it. How would this sit in the relation to public goods?
Well, in that case, they're not really, they perform maybe a public good, but also a private good, because that kind of thing where you go over the building code is often an insurance requirement, taking that as an example. So that's to satisfy, for example, to give an example, a deal with contractual obligations with an insurer. So they may not be a public good in that circumstance. You have the division between where something is a private good, common good, public good comes down to details. Speaking to the law, if you've gone above the building code on a particular element and you want to decommission it, you're not in question. It's not a question of breaching the building code, and you can go and basically proceed. You're still doing building work. It depends on the words of the jurisdiction, but you're probably in the category of. It depends on the specifics, to be frank with you, whether you're dealing with you may be not dealing with a public good situation. It's probably a private good.
Thank you. We have another question from Aaron Nicholson saying that we saw recently the Building Overseas Building Product Standards and Certification Schemes Amendment Act 2025 introduced in New Zealand that permits construction materials and systems tested or assessed to overseas standards to comply with the NZBC. What are your thoughts, and will we see something likely similar to that in Australia?
Okay, an interesting one. Trust Aaron to bring up a question that I haven't prepared for. Okay, I'll do my best. The purpose of that regulation, the purpose of that statute is to increase New Zealand's access to foreign products. And there's nothing wrong with that, so long as they're consistent with the purposive objective of the Act, which is they're going to serve a health, safety, and or amenity purpose. They're fit for purpose, basically. Overall, I'm in support of it. I think it's a good thing. I think Australia has a lot of barriers to trade on that front as well. And you have a better functioning performance-based building code for legally structured reasons. You have private certification over there, so it should be easier. Not that it is getting easier. So my view is it's a good thing. I hope people understand what they're dealing with on that issue, because they've still got to comply with the Act. And so overall, I'm pro that decision. Hopefully, I answered his question.
Excellent. I'm sure we'll hear from him if you didn't.
Okay.
There you go. He's giving us a thumbs up.
Thank you.
We have a question from Craig and saying that, do you see Australian consumer law increasing liability risk for fire engineers using performance-based designs?
No, it's what it is right now. What I do see happening is that with the increased regulations that you're having and the increased, I'm not saying Australia's turning into a police state over these issues, but I think that the direction you're going and how the regulations are being drafted in response to the issues you're having are not on track. And whilst there's an increase in occupational regulation, which fundamentally is a good thing, that there are two options on the table, situations on the table. One, there should be a greater level of freedom for trust for the individual who's registered to make those decisions, and not have people who are not registered get in the way of their decisions on the provision that they're liable for it. So you take responsibility. You go to a doctor, the doctor makes the decision. You should go to a registered engineer. The registered engineer has the decision, but you take the liability for it. What I am concerned about is, well, they're not incorporating that level of microeconomic efficiency into the market, which they should be. And I'd like to see engineers challenge governments on this decision. But the other thing that is most likely happening behind the scenes is that people can weaponize these kinds of complaints to get engineers to make design decisions that they wouldn't otherwise make for all sorts of perverse incentive basis. So, in other words, what's called frivolous and vexatious claims against engineers, and I don't think people have really made. I don't think engineers are not trained to think through these things, and I think there needs to be more industry discussion about that kind of thing, so that your industry is more productive on the whole.
Thank you. We have another question from Harley saying that a challenging situation I see is that we may be engaged to review a series of issues in a building. The remainder of the building is often designed by others and confirmed by the building certifier in Australia to meet the DTS/prescriptive measures. At what point does our liability stop as fire safety engineers, noting that NCC is a regulation and may be overruled where deemed inconsistent? Are we as fire engineers responsible for the entire building, which we often don't have the scope to review all aspects?
Okay, that's a big question. Okay. These things fall on where the contract is, where the common law, tort law fits, where the contract doesn't cover. So the starting point is determining where your contract stops. That determines where your liability is. And then there's the common law stuff like your duty of care. That said, there is an overarching risk to fire engineers if they are signing off on delegated legislation, regulations, compliance documents, deeming instruments that are not correct. You have a higher proportion of liability than the certifiers, the architects. Those are basically the three, and the project managers. The ratio of liability in order of heightened liability goes based on the case law: fire engineers, certifiers, architects, and project managers. Maybe the other way around with project. That would be the order. So you have a higher level of liability on these kinds of things. And given, I just have to add extra kind of point here, that fire engineering is such a small industry compared to, say, structural engineering, you don't have the depth of knowledge as an industry to draft to the same accuracy as what you'd expect in structural engineering. So on that basis, you're going to see more errors in your secondary instruments, regulations, and the like. So I think there needs to be far more heads put together on sorting this issue out, because I showed you a few examples and they just shouldn't be there. Hopefully that helps you somewhat.
Nice. We have a final question from Krishna saying that I understand that much of the countries that you have discussed here are Western democracies, that we will have differing structures and mechanisms in place. There is, however, a practice from the International Code Council to actively promote adoption of international building codes across countries. It currently focused on developing economies that has slowly spread its wings across Southeast Asia and South America. What would be the key aspects of adoption of a building code drafted overseas verbatim with minor changes complying to these countries that adopt it?
Well, if they adopt it, and it becomes law, and it all depends on how they go about adopting it. So if they don't have the drafting expertise to do it themselves, then that's just what they do. What I would say in those circumstances is that there's no liability for the people who draft it, because they've drafted it in a foreign country. So if they get things wrong, the country that adopts it bears the full risk. And I see a number of things on those code committees and the like. And speaking as an economist, I sometimes wonder whether it's just not people having holidays at the taxpayer's expense. That's really what I think a lot of it is. I don't think it's necessary. There's some usefulness to it, I think. I'll be honest, but not that much. But I don't think there's a problem so long as it gets checked. But be aware that they don't have to put in the same level of effort that a Parliamentary Council office would. Hopefully something useful there.
Excellent. All right. I think we are slightly over time there, so I might call it an end of today's presentation. So I'd like to obviously thank everyone online for attending, but more importantly, thank Dr. Christian Vanderpump for his presentation. Thank you all again, and hopefully I'll see you next time.